If you've got some less than professional messages on emails or your work phone, listen up. The Supreme Court just ruled that if it's on a government-issued phone, your supervisor can search it. Here to explain is John Mahoney, a federal employment and labor lawyer with Tully Rinke here in Washington. Give us some background on this case. It's fascinating, I think.
Well, first of all, thank you for having me on, Morris. This case arose in California, involved a city police officer in Ontario who was disciplined for sending sext messages on the government-issued BlackBerry. And as a result of an audit into the private use of the public BlackBerry system, he was searched, his BlackBerry was searched, and he was disciplined. The case went to the Ninth Circuit, which overturned the discipline, finding that he had a reasonable expectation of privacy under the Constitution to protect a privacy interest in his sext messages.
Well, that's right, because under the policy, the department had a no privacy rule, but he was led to believe that he could still use his cell phone. This goes for federal employees and even private workers. If they're using your company phone, email, or whatever, you assume you have some privacy. So this appears to be a landmark case.
It is a landmark case, and it's a unanimous decision from the Supreme Court, which holds that if a governmental employer, and potentially even a private employer, searches their property, their technology, and finds that their employees have engaged in misconduct, then it is reasonable for them to do so, and it is reasonable for them to discipline the employee. So in a federal situation, federal employees need to know that they really don't have a reasonable expectation of privacy in government-issued technology, and they should not be misusing that technology.
Now, this was also a slam dunk, too. There were no dissensions. Everybody was on the same page on this.
That's right. It's quite rare these days to have a 9-0 decision from the Supreme Court, and it sends a very clear message to federal employees and public employees that they cannot misuse government-issued technology for private use. Now,
this also goes, I assume, for emails. I mean, I've known people in the private sector, this goes back 20 and 30 years ago, when I was told, oh yeah, we expect our emails to be read and our phone conversations to be listened to. At what point is it good or bad or legal or illegal? For example, text, cell phones, they can look at the texting, they can, obviously we know they can read your emails. What about listening to phone conversations on company phones?
Well, that goes to a different statute, but the law is on that with regard to the federal government, that if one party to the conversation knows that it's being recorded, then it's legal for that recording to take place. So if a federal employee is listening to or is party to a phone conversation where the manager, for example, knows that he or she is recording the conversation, and the employee says something bad or misstates some fact or gets himself or herself in trouble, then they can be disciplined for that recorded phone call.
So bottom line, always assume Big Brother, your boss, is always watching.
And always listening.
All right, thank you very much. Interesting information here. John Mahoney with the Tully Rinke Law Firm. Thanks for the analysis.
Thank you, Morris.